Ladies and gentlemen, we're going to get started here pretty quick. Does everybody have their hearing appearance slips turned in on anything they want to discuss? Okay, if not, I call this Sawyer County Zoning Committee meeting to order. Kathy, can we have roll call, please?
Ron Buckholz.
Here.
Stacy Hessel.
Here.
Tweet Schuman.
Here.
Kay Wilson. Michael Maestri. John Righeimer. Thank you.
Michael Maestri is done.
Is he officially done or do you have to make him done?
Oh, he's officially done.
This year.
Sure. Well, he did that though, didn't he?
Okay.
Okay, so yeah. So, all right, Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Chair.
Find the way.
Needs to be stoppers.
I know it. All right. Number C, a statement of committee and hearing procedure and statement of hearing notice. The full statement of a committee and hearing procedure document, including directions for the individuals wishing to speak at a public hearing to be conducted at this zoning committee meeting, are available in the front of this room next to the agenda for today's meeting. The statement of committee and hearing procedure document is hereby incorporated into the record for this committee meeting. Any public hearing conducted at today's committee meeting has been published as a Class 2 notice in accordance with Chapter 985 of the Wisconsin statutes and in the Sawyer County Record and the Sawyer County Gazette ad posted. Now, Rebecca, we're going to have you address this. She on there?
Yep.
So we're going to have you speak on this right now.
You're on, did you guys?
As to the Class 2 notification requirements.
Yes.
Yeah, we can do this. Yeah, there's a few different places we can do this. From a general standpoint, Class 2 notification is set forth in Chapter 985 of the statutes, which requires 2 notices and 2 insertions into a publication that meets the statutory requirements. The statutes are very particular in terms of what meets the publication requirements, and both the Sawyer County Record and the Sawyer County Gazette meet those requirements. And I'll speak to these when we have a particular agenda item pertaining to the public hearing that there have been questions about the notice, because I think it's more appropriate for me to speak to those issues on that item. But I will tell you that there is no legal requirement, because the county has not adopted an official newspaper, that the notices be in the same newspaper. If the county had adopted an official designated publication, both notices would have had to run in that publication. We cannot find any evidence that the county ever did that. The clerk has searched the records, the county administrator has searched, zoning administrator has looked at this issue. There's nothing that there's nothing that can be located. So given that, it is appropriate that the publication for this meeting appeared in the Sawyer County Record and the Sawyer County the Gazette. And again, I will speak to the particular issues on the public hearing at that time. But as to the Class 2 notice for the meeting in general, it was noticed as a whole, it was noticed correctly.
Okay, Rebecca, I have one question. Publication, does it have to be in 2 newspapers? Can it be on something else?
It has to be in newspapers. It cannot just be online. We do have AG opinions on that point. So it does a class 2 or a class publication under chapter 985, class 2 has to be in a newspaper. It also has to be posted elsewhere. I think it's in the ordinance, I believe, too. It has to be posted in, I think, 3 public places, which is important from a notice standpoint. But the key to meet class 2 notification under chapter 985 is that publication in a newspaper that meets those statutory requirements for a publication.
Okay, thank you.
Yep.
All right, number E, approval of the November 15th minutes.
I'll make a motion, Mr. Chairman, that we approve the meeting minutes on November 15, 2023 as presented.
I'll
Okay.
second that.
Okay, we have a motion by Mr. Schuman, a second by Ms. Wilson to approve the November 15th meeting. All in favor, say aye.
Aye.
All opposed, motion carries. All right, number F, public comment. Please note, comment time is intended for the general public comments, not comments related to a specific application before this committee. Each agenda item requiring a public hearing will have its public hearing conducted just prior to the application being considered by the committee. If you wish to speak on a specific agenda item, we encourage you to hold your comments until then.
And as the chairman had illustrated here this morning, we are going to hold general comments under new business for the proposed ordinance amendment. So if you do have comments related to the proposed ordinance amendment, we'll wait until that time. Again, this here is for general public comments, and I have one sheet for those. Linda Zomer.
State your name and address, and you have 3 minutes.
Linda Zilmer, Edgewater property owner, Village of Birchwood resident. And first, I guess I'd like to address the class 2 notice. There are AG opinions out there, and they address the types of newspapers or types of postings. And it also addresses a official newspaper. That's right. A county is not required to have an official newspaper. But they also cannot have more than one official newspaper. So what has been the practice for Sawyer County has been the 2 consecutive week insertions in the Sawyer County Record and a supplemental kind of a courtesy posting for the people in the southern part of the county in the Sawyer County Gazette. The Sawyer County Record ran the first insertion on November 29th. The paper had a mispublication the second week, which would have actually, by the county's own ordinance, would have not met the publication requirement because state statutes require the second insertion 7 days before the hearing. Your ordinance requires 10 days before the hearing. And so I believe the class 2 notice has not been met. And just by way of verifying that, I contacted Beth Bennett, who's the executive director of the Wisconsin Newspaper Association. She feels that this does not meet the class 2 notice, and she also disagrees with what the Sawyer County Record did, in that when they have an e-edition, it should match the print edition. And what the Sawyer County Record did is then they went and they changed their e-edition to show the Sawyer County notices, and they've had no disclaimers, and I could not find a disclaimer in this week's newspaper. On a more positive note, I really did appreciate the good showing from Sawyer County staff and officials at the zoning training. So I'm really anxious to see today if the learnings were applied. It wasn't just training on the Board of Appeals and processes for zoning committees, but there was in-depth discussion on how to use a comprehensive plan and the importance of shoreland zoning for protecting water quality and habitat. And I think just pretty much everything covered in those 2 sessions can be applied today, and I would hope that you would remember that. And then finally, this morning, I sent in a general comment, findings of fact. Your findings of fact cheat sheet is supposed to represent your county ordinances, which are based on state statutes. This morning, I sent you an email with your authority and purpose under general zoning and shoreland zoning. And those are really the findings of facts that you need to base your decision on. Thank you.
Okay, thank you.
Mr. Chairman,
Yes,
I'm a little out of order here, but I would like to speak to that. And I think that it's appropriate if you would like to hear my response comments to those.
the committee would.
Okay. First off, if anyone is acting as legal counsel for an applicant or an interested party, I highly advise that the county let me know, because if there is legal counsel rendering legal opinions on an issue that could create county liability, I would certainly like to talk to that legal counsel. Second, I would warn someone who is not a licensed attorney to be very careful in rendering a legal opinion, because that is an unlawful practice of law as required by the law in our Wisconsin Supreme Court. So I'm just putting that out there. So be very careful, folks, if you're rendering legal opinions and you're not a lawyer. Second, if someone disagrees with my legal opinion, I am always open to hear and to listen to that argument. But I do take issue with someone coming to a legal conclusion that publication is wrong based on interpretation of statutes and attorney general's opinions that are not correct. And I will tell you, two things that Ms. Zillmer said are not correct. There is no inconsistency between what the ordinances require and what the state statutes require. Yes, there is different language, but a lawyer can see that that language is consistent. You have to look at the legal interpretation, and that is where Ms. Zillmer fails. And with all due respect to Ms. Zillmer, I know she is doing her best to be a good government advocate, but I take issue with the county and this committee receiving legal opinions that are not correct. And I'm sorry that you have to have me here as your legal counsel and pay for that expense. But when somebody renders legal opinions, particularly when they are not an applicant's representative, that creates liability and costs for the county. Thank you, sir.
Thank you, Rebecca.
Thank you. This is a public hearing in the town of Edgewater, rezone number 23-005, owner Hathaway Lodge LLC for the Stephen Arnold Friendshoe Trust. Property description is part of Government Lot 4, Section 20, Township 38 North, Range 9 West, parcel 0089382054002, tax ID 9231. It is 18.90 total acres, zoned Forestry 1. Purpose of the request is to rezone 4.7 acres and then subdivide into 3 additional lakeshore parcels containing 569 feet of shoreline on Little Sisibagama Lake. The 3 lots will be approximately 287 feet of shoreline, 136 feet of shoreline, and 146 feet of shoreline. This 4.7 acres would be rezoned from Forestry 1 to Residential Recreational 1. The remaining 13.3 acres would stay Forestry 1. The Shoreline Wetland Overlay District is not subject to change as part of this request. As part of my staff report, again, the purpose of the request is to rezone 4.7 acres of F1 as the underlying zone district to Residential Recreational 1. With that proposed rezone, the parcel will be split into 3 new lakeshore lots, and then the remaining 14.2 acres of forestry would be that additional 4th lot. Again, the shoreline wetland overlay is not subject to change as part of this request. The F1 zone district requirements would need to meet a minimum of 5 acres and 300 feet of width requirement, including 300 feet of lakeshore. Thus, the zone district change is being requested. With the proposed rezone, the applicant would then need to submit for a certified survey map, which is part of the preliminary map, which has been attached to this packet, would have 3 new lakeshore lots on Little Sisibagama Lake, and the remaining 14.2 acres of Forestry 1 would be that 4th additional lot. They would all have approximately 133 feet of width at a right angle and over 483 feet of depth. The Town of Edgewater Comprehensive Plan has 2 different versions of their future land use maps. The one version shows this area as shoreland or shoreland residential. Shoreland is defined by the Town of Edgewater's comprehensive plan, still references the old lakes classification system, which is no longer in effect. These lake classifications were initially intended to prevent or protect environmentally sensitive bodies of water. This property is located on Little Sisibagama and on an unnamed lake, which were wilderness bodies of water prior to the 2015 shoreline zoning ordinance changes that would have required 300-foot wide lots of water frontage and had a minimum of 5 acres. The town comp plan has a further future land use map with no buffer map, which shows this area as forest residential. With the no buffer map, the shoreline protection area is removed. The town then identifies this as forestry residential. As defined by that town comprehensive plan, it further goes on to state that it is recommended the density be 1 dwelling per 20,000 square feet within the Sawyer County zoning ordinances. There are 3 residential zoning categories that are represented by this, which is R1, RR1, and RR2, having all the same development standards. The site conditions in this location will need additional grading permits to ensure erosion control protection. And the proposed dwelling locations would be most likely located on slopes in excess of 40% in certain locations. I have done some initial, aerial imagery calculations on this, and the 3 proposed lakeshore lots would have over 5,000 square feet of buildable area. But again, they would need additional grading permits to assure erosion protection in this location. This is the second rezone request for this property. The previous request last year was to rezone the entire 18.9 acres from F1 to R1 with no future development plan. That previous request was approved at the town and zoning committee level, but failed final ratification at the county board on a supermajority vote in which that over 50% of the adjacent property owners filed a petition to protest against the proposed rezone. And that proposed rezone request now is only for the 4.7 acres as submitted as part of the preliminary survey map. I do have additional correspondence from the DNR as well as from the town. The DNR's information that they had sent back, note with the rezone from F1 to RR1 does not change the overlaying shoreline wetland district and associated requirements. The surface water data viewer indicates that mapped wetlands on this portion of the property, or that there are mapped wetlands on this portion of the property in question. The surface water data viewer also indicates wetland indicator soils across much of the property. The department recommends ensuring any use associated with the applicant's request meet applicable shoreline wetland requirements, including remaining outside any wetlands. The county would further have a 40-foot wetland setback and not creating discharge to any wetlands. Further, given that Little Sisebagama Lake is the western border of the property, the department recommends informing the applicant that any use associated with the applicant's request will also need to meet applicable shoreline zoning requirements. The department has no additional comments regarding any other request. As motioned by the town of Edgewater, motion was to deny, is a vote of 2-1 for denial. Their additional comments are kind of as their minutes from their town board meeting. Lots of discussion regarding the Hathaway Lodge request to rezone the 3389 Green Lake Road from Forestry 1 Zone District to Residential Recreational 1 Zone District. Meg Lattery and Brent Frenchue spoke in favor of the rezone request. Area residents spoke of their concern regarding the potential negative impacts on Little Sisebagama Lake should these 3 lots be developed. The board listened to valid points raised by all and agreed that as property owners, they have the right to request this rezone when other lots that are now developed were also previously zoned F1. The board also understands that the area residents are firmly in objection. Pete made the motion to approve with a second by Scott. This was then followed by more discussion, and the final vote was 1 in favor, 2 opposed, thus rendering a denial from the town, signed Natalie Clements, town clerk. There were 11 additional comment letters sent out to neighbors within 300 feet. We received 11 additional comments, all in objection. Those were sent to the committee. Did the committee have time to read those comments?
Yes.
Hearing and seeing nods from all committee members, those are now incorporated into the record. That is all.
Okay. All right. Rebecca, before we go into this public hearing, are we okay to go with, because classification in the newspaper saying that we're not legally able to do this?
Yep, so let's talk about that. I touched on it a little in the very beginning, but you're correct, Mr. Chairman, that even before you go into the public hearing, I recommend that the committee decide whether you want to hold the public hearing. Keep in mind that the purpose of notice and all of the public notice requirements in 5969 5E, 5 sub E, are, and the accompanying requirements in chapter 985 and the requirements of the ordinance are to give the public notice of what the county is considering doing, so the public has an opportunity to come and speak. That is the ultimate goal. So what I'd like you all to consider as we talk about this is whether you feel that the public has had sufficient notice. From a legal standpoint, my opinion is that how this public hearing was noticed meets the legal requirements. Now, we know that there's disagreement with that. But what I want you to consider is whether you feel that the legal requirements were met so that the public had proper notice. Okay, so with that intro, I'm going to go through this step by step again because of correspondence that you received on multiple occasions, and because of public comments, there is a heightened risk of legal liability for the county, and it's my job to clearly set forth a legal opinion to help guide you through these issues. So this is obviously a proposed rezone, and so we first look to the ordinances, which is section 13.21 of your ordinances, which calls out the statutory requirements of 5969 sub 5, which is appropriate. Because even though it's an ordinance, it has to be consistent with the state statutes. So 5969 says it requires that it's a class 2 notice, as do the ordinances. And this is a very preliminary point where I disagree with Ms. Zillmer's legal conclusion that these two are inconsistent. And this is where the value of, I guess, a law degree becomes helpful, because you have to look at the words and you have to apply principles of statutory interpretation. So let's talk about that for a minute. The ordinances say, let's just relays, notice of public hearings shall be given as provided in 5969 sub 5 or 59694 sub 6 Wisconsin statutes. The last insertion of a class 2 notice shall not be published less than 10 days before the date of the public hearing. Okay, so key language is shall not be published less than 10 days. Okay, the state statute, get to my 5969, says upon receipt of the petition for rezone, the committee shall call a public hearing on the petition. Notice of the time and place of the hearing shall be given by publication in the county of a class 2 notice under chapter 985. Okay, that then takes us to chapter 985. 985 says for a class 2 notice, all notices designated as class 2 notices require 2 insertions. Okay, well, what the heck is an insertion? Fortunately, the legislature gave us a description of the insertion, of what an insertion is. So that takes us back to 985-01. Except as provided in paragraph B, insertion, when used to indicate publication of a legal notice more than one time, means once a week for a consecutive week, for the last of which shall be at least 1 week before the act or the event. This is the language I believe Ms. Zillmer is saying conflicts with the ordinances. And it doesn't, because this says the last of which shall be at least 1 week before the act. At least 1 week. The ordinances say notice shall not be published, shall not be published less than 10 days. That means no less than 10 days. Statute requires no less than 7. Ordinance requires no less than 10. Last time I checked, 10 is less than 7. I'm sorry, 7 is, now I just messed up my own legal argument. 10 is at least 7. That makes sense? I hope I said that correctly. So statute requires at least 1 week Ordinance requires no less than 10 days. Those are consistent. Does anybody have any questions on that point? Because I know that is a whole lot of steps in statutory construction. Okay. With that then, now we go to some of the particular concerns with the Class 2 notification. So now we know what an insertion is. We know that it has to be at least 10 days before the date of the public hearing. Obviously, today is December 15th. Today is the day of the public hearing. So we had to have notice published at least 10 days before today. Our first notice, I believe, was on November 29th. Which ran in the Sawyer County Record. It was supposed to run again, and Jay, correct me if I'm incorrect on my dates here, was supposed to run on the 6th, right, Jay, in the record?
Correct.
Okay. Was supposed to run on the 6th, and the record made a mistake. So it didn't, but it ran in the Gazette. So a different publication, but it still ran on the 6th. So now the question is that okay? Is it okay that Sawyer County ran its publication in 2 different newspapers? So in order to make that determination, we go back to Chapter 985. Well, actually, we go back to the ordinances, first off. The ordinances do not say anything about publication in the same paper, okay? And the ordinances do not designate an official newspaper. And that is where the question of whether the county had ever designated an official newspaper became a significant issue, because that is one of the triggers of a statutory requirement. We couldn't find anything. So we're okay in the ordinances. Now going back to Chapter 985, it says under 985.05, when a municipality has designated an official newspaper, all legal notices published in a newspaper by such municipality shall be published in such newspaper unless otherwise specifically required by law. We know there's no other specific requirement by law because our ordinances are silent. And there's nothing in the statutes that requires publication in the same paper. So it says, if you have a designated newspaper, you have to publish in the same newspaper. It does not say you can't. Now, from a lawyer's perspective, I don't like that because it still doesn't give me that bright line answer. So statutory interpretation is interpreted by case law and is interpreted by our Supreme Court. Says, what do we do when there's either ambiguity, or how do we construe these statutes? And I think this is one point too that I don't want to put anybody to sleep, but from a statutory interpretation standpoint, this is what the law tells us. You look at the plain language, plain, ordinary, common, or literal meaning, and analysis, if analysis yields plain, clear statutory meaning, there's no ambiguity, and the statute is applied according to ascertainment of its meaning. So here we have plain language that we can apply. The issue is we don't have plain language as it applies to this particular question. So then what we do is we go to case law. If we don't have case law, then we go to Attorney General's opinions. We can go to secondary sources. We can go to, a plethora of other documents for guidance, but those secondary sources don't have the same legal weight as the case law, certainly, or an AG's opinion. So when I can't, and I looked on this issue, there's no case law on the point. Again, the question being, can we run in 2 separate newspapers if we haven't designated an official paper or an official publication? No case law, which for a lawyer is really devastating because that means we have to dig further. So then what do we turn to? We turn to AG opinions. Now, AG opinions are opinions rendered by the Attorney General. They are not binding under the law. They are guidance, but I sure would not appear in front of a judge going contrary to an AG opinion. They still hold a significant amount of weight. Courts rely on them. They just don't have the technical weight as a statute or a binding case, again, because of the rule of precedence. So looking to an AG opinion, Ms. Zillmer was correct that there are AG opinions that say you can't have two designated newspapers. Yeah, but that's not the issue here. The issue is not that the county is saying we have two designated newspapers. The evidence shows us that there is not a designated newspaper. So irrelevant that there's an AG opinion that says you can't have two. What an AG opinion does say in one line, if an official newspaper has been designated, however, the legal notice would be required to appear at least in that newspaper. So from my perspective, what does that mean? It means that if there is an official designated newspaper, you have to run the insertions in that paper. But again, that plain meaning applies to if you have a designated newspaper. Is it appropriate to conclude that you can run in two if you don't have an officially designated newspaper? Again, that's the ultimate question before the committee. So I look at this and I say, based on the theory of based on the principles of statutory interpretation, because there is no explicit prohibition, because the goal of class 2 notifications and all the provisions really of chapter 985 are to provide as significant notice as possible to get the public aware of what a government is doing. The question is, has public notice been given? And so again, based on the rules of statutory interpretation, when we put all of this stuff together that I've gone through, I conclude, and I have talked to Andy about this, and I talked to Matt Tome, our litigator, about this as well. The question is whether the county's publication in two different newspapers meets the requirements of the statute. And, while I certainly appreciate that, the head of the newspaper association said that, rendered a legal opinion that it wasn't sufficient. 3 lawyers in my office said, again, legally, it is sufficient. That's our legal interpretation. But going back to the very original question, do you think that it was legally sufficient?
Rebecca,
Yes.
can we move on here?
This is a lot. This is like a little mini law school class. And Sawyer County, unfortunately, is the only county that gets these little legal dissertations because you've got someone in your public who likes to render legal opinions that could potentially create liability, which is why it is so frustrating to me, because if a party has a lawyer, then I can work with that lawyer one-on-one and we can come to a legal conclusion. Sawyer County doesn't have that, unfortunately.
Yeah, so thank you, Sue. In a nutshell, you think that there's a legal basis to still hold a public hearing. Kind of up to this committee to further decide that. Looking at the responses that we got back from the separate notification letters that went out to 11 property owners and receiving all 11 comment letters back, looking in the audience and seeing the amount of public participation that we have here today, at least from the zone administrators' recommendation, I would recommend that you would hold a public hearing with that knowledge.
Mr. Chairman,
Yes.
I'll make a motion to go into public hearing on rezone number 23-005.
I'll second that.
Okay, we have a motion and a second to go into public hearing on rezone number 23-005. Any more discussion on that? All right, all in favor, say aye. All opposed? Motion carries.
In public hearing for the first hearing slip I have is Margaret Lattery for like to speak in favor of the application.
I gotta open it up though first.
You just did.
No, we just,
Yeah, you went motion.
oh, okay, all right. Yeah. All right, sorry. What I told him the other day, he said it ain't been out that long.
Yeah, would you like to speak?
Come on up, state your name and you have
Hi.
3 minutes.
Okay. Hi, Margaret Lattery, personal representative for Stephen French's estate and trustee. co-trustee with Mark Frenchu, who's also here. Just wanted to state again, as landowners, you know, we are within our rights to ask for this rezoning. And so that's why we're here today. And I think that's what this meeting is about, is the rezone. We did hire a forester to look at that property and walk it, and came back with that it is not, that the 4.7 acres that we're asking for is with, there is no value for forestry. And therefore, if there's no value for forestry, what is its value? R1, like many other lots on that on that lake. So, we think that is a consistent request. This is something that's done. And we would just like to be considered for our rezone. That's it.
Okay, is that all you want to tell us, ma'am? I didn't know you were the applicant, so you got longer than 3 minutes.
Oh, sorry. Okay, sorry. So I wrapped it up fast. I just think that when it is a beautiful lake, right? We've had property on that lake before, and yes, anybody that would be building on that lake would have to follow all the ordinance and guidelines that are set. So that is put in place to protect the lake. We are not trying to injure the lake. It is a beautiful lake. So I think from where we stand, there is no reason to not give our rezoning request consideration. And even if there is a lot of opposition, it is still not forestry land. It is not. There is no value. No one is contradicting our expert and his opinion, and therefore we just feel that that should be rezoned.
Okay.
And that's our case.
Thank you.
Thank you.
All right. Is there anyone out there that wants to speak in favor of this rezone? Is there anyone out there that wants to speak in opposition to this rezone?
First I have for opposition is Don Kissinger.
State your name and address, sir. You have 3 minutes.
Thank you for allowing me this opportunity to speak. My name is Don Kissinger. I live on Little Sissebaugma Lake at 16354W Legacy Ridge in the town of Edgewater, and have a permanent residence with 230 foot of frontage with the residence that I've placed in the middle. So I had 2 lots I placed in the middle. Ecologically, that's the best place to put it. And for 60 years prior to that, I have been on this lake seasonally with the family cabin. I retired from the DNR in April of 2021, where I worked as a regional urban forestry coordinator for 29 plus years and worked with our water regs and zoning personnel related to buildings of structures near wetlands as an offshoot to my position. Thus, I have a natural resources background. I'm opposed to the rezoning application submitted by Hathaway Lodge LLC, specifically in reference to several of the finding of facts for denial issues that you, the zoning committee, must consider. They are, number 11, will the zoning change be detrimental to the ecology, wildlife, and shorelines area? Yes, if as proposed and changed from forestry to residential recreation, and the full length of the shoreline is allowed to be platted at its maximum use. Trying to shoehorn homes within the confines of most of these lots would necessitate major alterations to the land and adversely affect the 2 wetlands present, the larger one contiguous to the lake, as well as a smaller perch wetland with slopes around it. Thus, the water quality, ecology, and wildlife use of that portion of the lake will be harmed. The developer has not shown on any map proposed locations of these buildings or driveways, which I think is important. Number 12, will it create air quality, water supply, or pollution problems? Very likely. Pollution problems may occur if vegetation is removed above the wetlands, slopes increased, and fill is used to allow for the buildings as a resulting sedimentation will choke out the wetlands plants that act as the lake's kidneys to cleanse the runoff. Number 13, will it create topographical problems such as runoff, drainage, erosion, flooding, or the removal of vegetation cover? It definitely will. If the maximum allowable lake lots occurs, in order to meet all setback requirements such as from the town road, adjacent lots, distance to the lake's normal high water mark, distance to the freestanding wetland, distance from well placement, as well as septic systems. In order to accommodate all of these very valid requirements to build a home on each lot, there would need to be a substantial amount of grade change, basically cut and fill of the current slope. Excessive vegetation removal will result in increased runoff, erosion and sedimentation entering the lake, adversely affecting the microorganisms of zooplankton, phytoplankton, amphibians, and fish. In closing, this is a parcel of property where more than half the shoreline is wetland, has another perched wetland, substantial slopes, and a town road nearby, which ecologically speaking should only accommodate one building without any variances.
Thank you.
Thank you.
Next, we have to speak in opposition to the application, Chuck Abrams.
State your name, address, and you have 3 minutes, sir.
Thank you. Chuck Abrams, 3340 Mallard Lane, Stone Lake, Wisconsin. I'm also a resident in Little Sisebagma. My property is adjacent to the wetlands that are the furthest edge on their property. I'm not going to reiterate all of the findings of fact that Don did because he did so well. So I'm going to come at this a little different. In one way or another, as homeowners or renters or business owners, we've all benefited from development in the past. None of us was going to argue that fact. But the issue before us is not about stopping all development. This is about recognizing the challenges that this development puts before us, and we want to promote and encourage responsible development. The rezone request is not just about any piece of land. Frankly, if this was anywhere else on the lake, none of us would probably be here. So what matters right now is not whether the proposal meets what past development has been. What matters is are willing to pause this and ask what is the right thing to do today, not what was done in the past. The land within this request is some of the most sensitive land as noted by the DNR and Don. This rezone encompasses 3 proposed lots that are in the heart of a wetland and wetland soil and is directly in contact with lakefront wetlands. On the maps, you'll see that there's a shed indicated near the wetlands. That's actually a pole barn built on a raised platform because it sits in a wetland, as that map indicates. The proposed development would make this one of the most highest density developments in all the areas of the lake. Last year, the applicant stated in all probability he'd only be able to fit 1 home due to the topography, even though the rezone was for more. That's what the county decided when their vote to deny. Today, we face a similar request. While the majority of the property is not under rezone request, the only area that is suitable for any kind of building is being proposed to have not 1 structure, but 3. The applicant has said that there could be 1 home built, or 2, or 3. And last night, there was the possibility that no buildings would be built on this. The uncertainty from the applicant should serve for all of us as a red flag that they have no idea what they're going to do on this property right now. And that's why you should vote to approve their rezone. If we're to protect our most sensitive areas for future generations, those of us in opposition humbly ask that this rezone be denied. Not to deny any development. We're not doing that. But this is to promote responsible development for years to come. Thank you.
Okay, thank you.
Next, I have to speak in opposition, Linda Zomer.
You have 3 minutes.
Linda Zilmer, Edgewater property owner, and I was on the planning committee for the town of Edgewater that drafted the comprehensive plan. And I was the first plan commission chair and a plan commissioner when the plan was first being implemented. And I speak from experience. I have never claimed that I am making a legal opinion. I've never claimed to be an attorney. I do my homework to try and make sure that before I bring a issue to you, I've done my homework. I share what I've learned. And if the county had given me courtesy of an explanation in response to my emails, I don't think we would have had the drama, but the civics lesson is appreciated. And when I contacted Beth Bennett, it was just to see if maybe she could correct me because I was not getting response from the county. And it was not her legal opinion. It's just, again, from her experience. The Town of Edgewater Comprehensive Plan has been misstated in the staff report a couple of times now, and that has happened with other towns too. The Shoreland Overlay District on the future land use map is to indicate that more stringent consideration is due to anything within 1,000 feet of a shoreland. So that even though the underlying zone district says forestry residential, that higher density 20,000 square foot is outside the 1,000 feet, which this rezone is not. The town's intention was to recognize that at the time the plan was adopted, there were three classifications of lake with a lower density level, the more sensitive the lake. Just because those zone classifications went away does not negate the town's plan or as you have adopted it into your county plan. The intention is still that within 1,000 feet of a lake, you need to be more restrictive, just as your county ordinance is. Outside of that 1,000 feet, yes, the town plan does say forestry residential can have smaller lots, and all the text of the plan justifies not developing wetlands, not developing slopes, and it suggests other means of rural development that your zoning ordinance also suggests, but rezoning these into shoreland lots that are that small almost necessarily forces future variance requests. And I think there's been training now on variances that you need to meet 5 criteria. And I think this would be self-created hardships by creating these lots. Thank you.
Thank you.
We'll call for any other.
Okay, is there anybody else out there that wants to speak in opposition to this rezone? Yes, ma'am. State your name and address. 3 minutes.
Thank you for letting me speak. I'm Sue Kissinger. I'm 16354W Legacy Ridge. I'm a permanent resident on Little Sisebogama. I just wanted to address 2 things that didn't get talked about. One, and I do have a background in forestry, so I feel like I can address this. One is the forestry expert that was brought to look at this property. This is a little teeny property. There is no forestry value on harvesting on a property of this size. So I question that information on whether this should be a forestry or recreational property. Plus, the property, especially the one that's being discussed today, is of such small size, and a huge majority of it is wetland and wetland soil. So that would not be of forestry value, but it's also not developable because of the value of these wetlands. And the other thing I want to stress, Chuck mentioned it, but I really want to bring this home. This is not anything, this is not a vendetta against the Frenchu state or anything. If anybody owned this property, if anybody was trying to develop this property, we would be saying, this is not right. This is not a property that should be developed to this density. The wetlands on this are so important to our lake. If this was any other parcel on the lake with less slope, with no wetlands, develop. That's anybody's right. This piece of property is so valuable to our lake. It is because, as Don mentioned, it's the kidneys to our lake. Those wetlands are helping to filter and protect our lake. So please just remember that as you make your decision. People have a right to develop. We're not saying don't develop our lake. It's special. It's this piece of land should not be developed because of the slope, the wetland soils, and the wetland and how it protects our lake. Thank you.
Thank you, ma'am. All right, anyone else out there want to speak in opposition to the rezone? Anybody online or Jane or no?
If anyone online wishes to speak, you'd have to indicate by raising your hand as to the Zoom button to raise hand to speak. And seeing none.
Okay. All right. I need a motion to come out of rezone public hearing on 23-005.
Motion, Mr. Chairman.
I'll second that.
We have a motion by Mr. Schuman, second by Ms. Hessel to come out of public hearing on rezone number 23-005. All in favor, say aye. Aye. All opposed, motion carries. We are now out of public hearing.
This is the discussion action for the town of Edgewater rezone number 23-005, owner Hathaway Lodge LLC per the Stephen Arnold Friendshoe Trust. Legal description is previously read into record. This request is to rezone 4.7 acres of Forestry 1 to Residential Recreational 1. As part of kind of a summary for the committee, I did have conversations with the Northwest Regional Planning Commission in regards to the comprehensive plan. And even though the intentions of the comp plan may have, had this as, shoreland as an overlay protection district, that's not to say that the shoreline overlay protection would go to the requirements as what the comp plan is. It would go to the requirements of what the current shoreland district would allow. And the current shoreland district would allow for, be it either, development, but to have, the protection for setbacks from the water, for erosion control measures, for non-filling of wetlands. So I just kind of want to make that, clear. Also in regards with that conversation that I had with Northwest Regional Planning, even though there are, two different future land use maps as shown, one being for the shoreline, one being for this forestry residential. They did indicate that any recommendations from this committee should rely heavily on what the town's desires or what the town's had indicated. And per motion of the town, they did deny the request 2-1.
Okay. All right, committee. Turn it over to you. Schuman.
Mr. Chairman, I'll make a motion to deny rezone number 23-005, citing the findings of facts number 11, 12, 13, and 17.
Can we go through those as part of
Yeah, we can.
your motion, and to why you're basing that finding off that checklist, just to have more of a legal analysis, a legal background for that?
Well, I cited 11, 12, and 13. I agree with the wetland protection, the shorelands. I believe with the water pollution and supply problem with the drainage and runoff that may occur with a construction area. And then, and same with 13 regarding the drainage, runoff, erosion. But I'll leave out 17 and 18 because I'm not sure which comprehensive plan applies to this area. I think there were multiple you were telling.
Yes, there was, and
So I'll leave it, Jay, with 11, 12, and 13 as my findings of fact.
Okay, we have a motion to deny. Do we have a second?
I'll second that.
Okay, we have a motion by Mr. Schuman and a second by Ms. Wilson to deny the number
23-005.
yeah, 23-005. Any more discussion?
Mr. Chairman,
Yes.
as far as number 17, I would like to address that because when we had our meetings, they said that base your decision on the comprehensive plan. And the town of Edgewater in their natural, agricultural, and cultural resources chapter number 7, it says protect and preserve the township lakes. And their resource identification action is identify and implement town ordinances that will preserve and protect the area lakes. The Sawyer County Comprehensive Plan 21-41 under natural, agricultural, and cultural resources has a goal to promote and sustain use and management of the county's environmental diversity, natural resources, and related quality of life. Objective 2, protect lakes, rivers, streams, shorelands, and wetlands.
Okay. All right, any more discussion? Roll call, Kathy?
Ron,
Yes.
Ron Buckholz.
Yes.
Stacy Hessel,
Yes.
Kay Wilson,
Yes.
Tweet Schuman,
Yes.
John Righeimer. 4-1.
Okay, thank you.
Moving on, this would be a good time if you wanted to. Okay. This is a public hearing in the town of Hayward, rezone number 23-013, owner Cedar Falls Building Systems, Inc., part of the southeast one quarter of the southwest one quarter, section 28, township 41 north, range 8 west, parcel 010-841-283403, tax ID 11471, zone commercial 1 is 5.03 total acres. Purpose of the request is to rezone the 5.03 acres from commercial 1 to industrial 1 for manufacturing of park model trailers and the repair of golf carts. As per my staff report, again, the applicant is requesting to rezone 5.03 acres from commercial 1 to industrial 1 with the attached maps included within my packet. The proposed rezone would result in conforming zone district dimensional requirements. The purpose of the request would then to have a permitted use within the industrial 1 zone district for manufacturing. Manufacturing is only allowed within that industrial zone district. The golf cart repair aspect would also be a permitted use within the industrial 1 zone district. Again, their intent of the rezone is to have park model manufacturing. Basically, they want to build park model trailers in an existing building that's on the property already. For those that aren't aware of where this property is located, it is right across the street from the LCO Casino on County Highway B. So not County Highway K, County Highway B, it's to the north of the LCO Casino. There is a larger block of commercial land in this area along the Highway B, Highway K corridor, as well as the LCO Casino just to the south of this property. The future land use map for the town of Hayward shows this area as rural trans or rural transitional RT. RT is defined by the town of Hayward comprehensive plan is to identify certain lands in proximity to developed areas to be preserved mainly as forestry and open spaces until such time as more intense development may be appropriate. Areas within the RT classification shall be transitioned and new development shall be limited in accordance with all town policies, including the Highway Corridor District. Appropriate Sawyer County-based zone districts within RT do not include commercial 1, but the town does not require an amendment to the future land use map if the town determines that a new classification is appropriate for more intense development. There is no other industrial zone districts within this immediate vicinity. This may be viewed as spot zoning, but spot zoning is not necessarily illegal because such zoning is not necessarily inconsistent with the purposes for which zoning ordinances can be passed. However, rezoning should be consistent with long-range planning and based upon considerations which affect the whole community. Therefore, spot zoning should only be indulged where it is in the public interest and not solely for the benefit of a property owner requesting the rezoning. This area does contain a considerable amount of commercial development and commercial facilities. This anticipated use would be more so considered a light industrial commercial use, but the zoning ordinance would only allow manufacturing within the industrial 1 zone district. As by action of the town board, motion was approved. Gary Gedhart, chairman, Andrea Whitward, supervisor. Gary Inhofe was absent, so it passed 2-0. As per action of the town board, covenances are to be placed on the property deed and continues with the transfer of sale. With a rezone from commercial to industrial, a covenant is to be placed on this property that only assembly of materials encompassing the steps of constructing and finishing products from components or compiled units assembled that are ready for sale and repair of motorized conveyances transporting someone or something from one place to another by use of motor are allowed. The covenants can only be changed, modified, or removed with the Town of Hayward Board of Supervisors approval, signed Bryn Hand Town Clerk. There were 4 additional comment letters sent out to adjacent property owners. None were returned, and you did not receive additional notification from Nita Kemp? No. We had correspondence with LCO real estate agent liaison Nita Kemp. And I don't think she was able to get a final answer from the board, from tribal governing board, as to their comments regarding this. That is all.
Okay. Thank you. I need a motion to go into public hearing on rezone number 23-013.
So moved.
We have a motion by Ms. Hessel and a second by Mr. Schuman to go into public hearing on rezone number 23-013. All in favor, say aye. Aye. All opposed? Motion carries. We are now in public hearing. Is the applicant here?
Gary Nathan, 10762N Pine Crest Drive, Town of Hayward. I'm here on behalf of Mark Lewis, owner of the Cedar Falls Building Systems. And adding to what Jay said, yes, the property is located at 13700 Highway B. It's a 5 acres. There is a building on the property now, a 90 by 60 building. And actually, the purchaser of the property is here today too, Mr. Don Robinson. And it's Mr. Robinson who is proposing to build park models. And I believe I'm correct in that he's the owner, as you know, of Chippewa Campground and has, I believe, 33 employees during the summer period. This will provide an opportunity for, his employees to continue to work during the winter. He can build park models for his current Chippewa Campground, and Ken also obviously would be able to sell those. I was at both the planning hearing for the town as well as the town board meeting, and it did pass unanimously. Mr. Lewis is the one willing, as you know, to place the covenant on the property so that in the event the property would sell in the future, that if there was to be any other type of business operated out of that, it would have to go before the town board. And that's all I have to say.
I guess I have one question. What is the nature of the timing for recording of the covenants?
We would have to record those prior to the sale of the property.
Okay.
Yeah, and I'm not supposed to disclose the terms of an offer, but I would say that there'll be plenty of time in which to do that.
Right. And the only reason I guess I asked that to you, Mr. Nathan, is this committee, when looking at a rezone, cannot necessarily place conditions. Now, the town could have, recommendations that a covenants be placed, but when this committee makes a recommendation to county board for ratification, it can't come with a condition that the covenants be recorded.
Understood.
So there is kind of a little bit of a timing aspect where I do feel that this committee potentially wants that covenants on there, but they can't put it on there.
Understood. I think Mr. Neese is here today too. The placing of the covenants with respect to it never being modified or removed unless the town board were to approve that is not inconsistent with what's done in the past. I believe both in the town of Hayward, Phil, correct me. I think town of Bass Lake, we've done this too. So it's not an inconsistent move on the part of the owner.
Okay.
Thank you.
Great. Thank you.
Mr. Chairman, I got a question as long as
Oh, go ahead.
the applicant or Mr. Nathan was here. And it's also for you, Jay. Jay, I have concerns with the spot zoning and rezoning this industrial.
Mhm.
Would that be inconsistent with surrounding use of the area?
I think I might be able to, I'm sorry. Go ahead.
And does it fall within the town of Hayward's comprehensive plan?
Yeah, so as per the staff report, yes, this could be viewed as spot zoning, but spot zoning is not per se illegal if it is consistent with long-range planning. And when we look at long-range planning, as to the aspects of, again, the town comprehensive plan, the town's desires, the town did make a recommendation for approval. When you look at, the surrounding uses of the area, the surrounding uses of that area in what I like to call the County Highway B, County Highway K corridor, that's our next kind of mini hub for commercial, in my humble opinion. You have a bulk fuel storage facility. You have a Subway restaurant. You have a Jump River electrical building. You have a
Well, you have a welding shop,
welding shop, a
auto
large
body.
storage building, the LCO casino, a golf course. So I mean, this is our next hub of commercial. And the proposed use is more of a light industrial commercial, again, manufacturing mobile home trailers. And that's where I do kind of like the route that the town went as part of putting the covenants, because you look at some of the other allowed industrial uses.
Mhm.
I don't think anyone wants to see, you know, a chemical manufacturing plant in that location, right? But to, you know, say that someone's going to bring in some metal and some wood and some electrical wires and fabricate and manufacture up a park model trailer, well, that's, you know, that's fits in line with like a light industrial commercial type of use. And, you know, if it's not, you know, this area, I guess I would question back to the committee, well, what other areas would you like to see commercial and industrial increase in our community? Because ultimately that's going to be needed in the future generations to come.
You covered everything that I would have and more. Thank you.
Thank you, sir. All right, does anyone else out there want to speak in favor of this rezone? Go ahead, Mr. Neese. 3 minutes, state your name and address,
3 minutes. I've never.
if you can last that long.
I'll try. Joan usually does this, but she's not here today for some reason. So I'm vice chairman of the Town of Hayward's Planning Commission. The town really spot zoning, probably the greatest example of spot zoning in Sawyer County is B. That section. I mean, if you start with the auto place all the way down to the casino to all the things that's been described. We presented some or what we thought would be objections to the applicant. And so they offered to put a covenant on to try to restrict it, because the use of what they were going to use it for, if it was just pure industrial without a covenant, we would not have passed it because it would have allowed too many things. So, or I don't think we would have, but anyway, you can't say that. But anyway, the reason that we wanted the word assembly used rather than manufacturing, because there is a difference. And also, we're not, even though the applicant, or not the applicant, the purchaser of the property, he thinks he's going to do part models or something else, and he thinks he's going to repair maybe golf carts. Maybe he won't. That's the reason that we tried to keep it wide enough in that it just didn't specify those items. That you could, if you want to assemble bird houses, you could. So anyway, the town felt, because was okay with our comprehensive plan. And we thought long and hard about this, because we certainly don't want, if you use the word industrial across from the casino or whatever, but it's far enough down. I think any traffic going in and out have nothing to do with seeing it. So anyway, thank you. Any question?
No, I don't. Board, committee? Thanks, Bill. Right, anyone else out there want to speak in favor of this rezone? Anyone out there want to speak in opposition of this rezone? Anybody got any? They don't look like it.
Nope.
Okay. All right. I need a motion to come out of public hearing on rezone number 23-013. Mr. Schuman.
Motion to come out of.
Second.
We have a motion by Mr. Schuman, second by Ms. Hessel to come out of public hearing. All in favor, say aye. Aye. All opposed, motion carries. We are now out of public hearing.
This is the discussion action in the town of Hayward, rezone number 23-013, owner Cedar Falls Building Systems, Inc. Legal description is previously read into record. The request is rezone 5.03 acres from commercial 1 to industrial 1 for the purpose of manufacturing / assembling park model trailers and repair of golf carts.
Okay. All right, committee. Cecil.
I make a motion to approve the rezone of 23-013 and applaud the effort.
Find
Okay.
facts with those.
I was all excited. 1 through 9.
Okay, do we have a second? I'll second that motion.
And then as part of discussion, Rebecca Roker has her hand raised.
Go ahead, Rebecca.
Thank you, sir. I just wanted to reiterate what Jay said, that technically, because this is a rezone, the county cannot condition a rezone on the recording of those restrictions. I just wanted to, again, reiterate that because if you are voting yes based on that condition is not proper. And let me know if you have other questions. I'd be happy to answer those. Thank you.
Thank you, Rebecca. Okay, we have a motion and a second. No, any more discussion? Okay, roll call, Kathy?
Stacy Hessel,
Yes.
Kay Wilson,
Yes.
Tweed Schuman,
Yes.
Ron Buckholz.
Yes.
John Righeimer.
Yeah.
All in favor.
Okay, thank you.
Can I use the bathroom, Chairman?
All right, we're gonna take 5 minutes here. Yep. Then Stacy can get it out.
Sorry about that.
Yeah. Okay, I call this zoning committee meeting back to order. Okay, number 5, new business.
Yeah, so no conditional use permits this month, woohoo. And as part of new business, bringing back up the proposed ordinance amendments regarding multi-dwelling development. 2 months ago, we invited town officials to the zoning committee public hearing to really kind of, engage with them and see what they wanted as kind of a long-term approach for the enigma that is the multi-dwelling development portion of the Sawyer County zoning ordinance. So with that, we have version 5.2. This is the red line version of 5.2. I did have some help kind of drafting this. Mr. Phil Neese and Mr. Don Stover were kind enough to render some of their opinions with helping of the creation of this version 5.2. A lot of the feedback that we got from the town officials 2 months ago was that we really kind of wanted to see this as what we call as a two-state type of ordinance, where we still wanted to have the allowances and the potential for whether it's multi-dwelling development, whether it's for condominium ownership, whether it's for larger family compounds to be built, whether it was for more tight-knit residential communities all on one lot, but not within shorelands. And that's how we crafted the version that you have in front of you. Is we'll still allow this multi-dwelling development if you have a larger parcel of land that meets the dimensional requirements and you want to put 4 dwelling units out there and rent them out, whether it's for lower income housing or just housing in general, but not within the shorelands. Shorelands is defined by the Sawyer County General Ordinance and defined by the Sawyer County Shoreline Ordinance, is land within 1,000 feet of a lake or pond or 300 feet of a river or stream. So basically, again, in order to do any type of multi-dwelling development, it's got to be outside of the shoreland area, which again, 1,000 feet from a lake or pond, 300 feet from a river or stream. From there, we kind of, cleaned up some of the other definitions. These definitions, really haven't changed through any version of this amendment, except when we get down to the definition of a resort. Because in discussions with Mr. Neese and with Mr. Stover, there are a lot of scenarios that all of a sudden turn into a very large snowball as you start thinking about the hypotheticals, the what ifs, and the unintended consequences. Because there are a lot of existing dwelling units that are out there that are on one lot. There are a lot of existing lawfully placed dwelling units that are out there within the shorelands on one lot. And so that's where we still said, if we have a condominium form of ownership and there's 8 units within this condo, and Mr. Schuman wants to rent out his condo unit and try to make some extra money because he's only there, a few months out of the year. One of those rentals within this 8-unit condo is fine. That's not a resort. You're only renting one. Now, Miss Wilson sees that, well, Mr. Schuman's making a bunch of money renting out his unit as part of this condo. And now you want to do it as well and make some extra money. Well, now you're renting 2 units on one lot. And that, as per ordinance, would be and constitute as a resort because you are renting more than one dwelling unit per lot. Now, again, there are already existing dwelling units there. No one's adding new dwelling units. It's the use of the rental. And so that's where we said, okay, if you're wanting to do that, you shouldn't really be penalized or have no opportunity to do that, but you need to come in and get a conditional use permit to operate as a resort. And then the town at least gets a kick at it and zoning committee gets a kick at it. And you can potentially put other conditions on there because maybe I'm stuck in the middle of both of your units. And maybe one of the conditions is now you have to put up fencing so that I don't hear or see the rental neighbors that you may have. That's where we thought that's the best kind of approach that we can make to this and kind of satisfy everyone involved, at least if we're going to allow more than one rental unit on one lot. It would at least be as a conditional use permit to operate it as a resort. Yes, conditional use permits can be difficult to deny without substantial evidence, but you could at least instill certain conditions that would mitigate some of those complaints that we would hear from that kind of aspect.
Jay, has legal reviewed this and approved this?
Yeah, so they have looked at it. I wouldn't say they gave a thumbs up approval yet, but they did have some additional questions, but did review it and did want me to at least put it on the agenda. We have it as of right now for discussion action to potentially send out to the towns. The general process that we've always done for ordinance amendments is we craft, we tweak, we tune, we listen to some comments from the audience, and then send a version out to the town. The town's review, it then comes back to us, and then we hold the official public hearing process.
Sure.
If that makes approval through the official public hearing process without a large or substantial change to the proposal, then further goes on to county board for final ratification. So Rebecca has at least looked it over. I don't know if she's, thumbed up the final approval. She had some questions as to, how we're defining, the shoreland aspect. But again, that was, what we had heard from the towns. They wanted this basically, again, that 2-state approach where if you want to do new multi-dwelling development, it's only going to be allowed in non-shoreland districts.
Got it. And then, Mr. Chairman, did I hear you say that we're going to allow the towns to speak during this? Again,
Yes.
because they have a red line version in front of them. I would really like their opinion.
Yes.
Well, it
Thank
wouldn't
you.
necessarily be the towns. I mean, the town officials could have came, but there are some, members of the public that
Yeah,
really want to speak.
I'm sorry, that's what I meant. Yep.
And when I allow you to speak, you're only going to get one chance to speak. You're not going to get twice. And when we do this, I don't want to hear bad mouthing anything about it or whatever. Just state what you want to state. And so we can move on here. So we only have one that signed up to talk to us. How many out there want to talk? Raise your hand.
Oh, there's probably some people online that want to speak
Okay.
on this as well.
All right. Okay. Let's go with Doug.
Yeah, first, we'll go with Douglas Kurzweil.
Douglas Kurzweil, 11055W Arrow Road, Hayward, Wisconsin. I got to admit, this 5.2 version is the best of the 10 or 12 versions that I've seen over the last year and a half, and you're making great progress. And I could almost get on board with this. There's a couple of inconsistencies that I find. There's a couple of things that are confusing. Again, I've talked with several other officials about this, and I've heard comments confusing, conflicting. One said incomprehensible, but the text became available online Wednesday afternoon, and I've had a chance to read through it a couple of times. Like I say, there's a couple of inconsistencies, minor language changes, conflicts, and I think in the definition of multi-dwelling development. One of the big things I wonder why a multi-dwelling development, which could be 3, 4, 8, 10 units, why there are not lot size restrictions on that as there are for a goddamn duplex. That seems a little strange, but some language that caught my attention that seems really kind of vague. And it says, existing lawfully placed. And I think the professional, precise zoning term would be conforming. And other than that, I think we make a few tweaks in it, clean it up a little, and then maybe send it out to the towns. Between now and the July meeting, we've got a couple of holidays, and I believe there are 3-day holiday weekends this year. A lot of people travel, etc. Also, we've got, I believe, at least three of the towns impacted by Sawyer County zoning are having board member elections this spring. Also, the entire county board is up for election this year. And as far as I know, there's going to be at least 2 new members. One has filed a notice of non-candidacy, and I guess another one has resigned from the board completely or something like that. And I have no idea who's all circulating papers. So I don't really see a need for this to even get too far down the road until probably the April zoning committee meeting, which comes several days after the county board's reorganizational meeting. So I think we've got the time to tweak this a bit and then maybe send it out to the towns in January or February. Because again, nobody's going to be building multi-units anywhere real fast, even though there isn't much frost yet. Thank you. And again, my commendation to Mr. Kozlowski and the folks that he worked with in crafting this. I think we've made great progress. Thank you.
Thank you.
And I can certainly speak to some of those. I guess because this committee and because the towns have at least seen this and have made their comments, I guess I would like to try to proceed with the current board structure before there's turnover and those not even knowing what's going on because they're just getting thrown into it. So I would like to definitely see something before April turnover, in my opinion. And to the aspects of multi-dwelling development, as per the zone district requirements, it does state that each dwelling unit must meet the minimum dimensional requirements as contained in section 18. So it does have that if you want to start up a new multi-dwelling development, you need double the lot area, lot configuration requirements for each dwelling unit. And I don't know where the feedback's coming. I'm not an IT guy. So.
But that's a dwelling unit dimensions, not lot dimensions. That's
what?
Part of the language that I was speaking to. Here.
Okay.
Okay,
It's yours. You speak.
Denise, you're up next. 3 minutes.
I appreciate what Doug had to say. Don and I and Jay met for hours on end, and part of it was trying to find the unintended consequences no matter what you do. And the reality of it is, and we ran through scenario after scenario, situational things, how that's going to affect, things we know about. I guess this has been a process of, it's been over a year, then the beginning of all this. And so anyway, my point would be that the process that's in place is that if you send this out to the towns, they can have a chance to voice something. And when we're coming back to public hearing, if there's small tweaks or whatever, we've done it forever, or changes or whatever, or it's not accepted, that they can't accept it, then I guess we have to start over again. But I sure hate to see at this point in time that in deference to Doug, but to see it, we're close enough to something that, and I think this is a good document. So not because I was involved in it, but I was, so. Okay. All right. Next.
Linda Zilmer, Edgewater property owner, Village of Birchwood resident, and was on the committee that updated the Sawyer County Comprehensive Plan. This draft right now, I would argue, on course, that is not as good as the previous ones, and it is not consistent with your Sawyer County plan. The draft that went to the towns, the objection is that there was a change to allow more than one dwelling on a lakeshore lot. And if you look at your entire zoning code right now, if you look at your general zoning, the definition of a lot only allows one dwelling. And in your subdivision ordinance, it allows only one dwelling. I don't think you want to open up the county to having multiple dwellings on single lots, because I almost believe if, you look back in time, they probably put that language in there as a result of the problems of the old resorts on Lakeshore, and it wouldn't have to be necessarily Lakeshore, where you had non-conforming buildings, and when you split up those buildings into separate ownership, it created non-conforming lots. And that's essentially the situation you would set up with the future with the way things are changed here. In the email I sent you, and there's a couple of them, I suggested that you might want to look at how ATCAP 72 is being redrafted, and that covers tourist rooming houses. They start with the definitions that are in the statutes, and they go to administrative rules. And I think that's the process that should have been done from the beginning here. And so if you look at how dwellings and multi-dwellings are defined in statutes and administrative rule, to make the county zoning ordinance more consistent with that would be helpful and alleviate confusion. And so there are provisions that I keep saying that I don't understand why anybody in zoning hasn't raised them yet. There are provisions to allow cluster type development in the county. There is a provision that would be suitable for the town of Hayward when you talk about affordable housing, to have development patterns. And I don't know why the county would want to allow more than one dwelling on a lot when they could be separate and alleviate problems in the future. So that is the draft I sent you this morning, as well as a draft definition for a resort that addresses that it's lodging and not residential. Thank you.
Thank you.
Yes, my name is Donald Stover. And I live at 11518 North Farnsworth Road in Hayward. I'm also a Town of Round Lake supervisor, and I was involved with the work on version 5.2. Yes, it's not perfect. Yes, we probably should have some tweaks down the road. But the one thing that version 5.2 does do is it helps protect our lakes and our shorelines. And that is something that we need to be really concerned about as we move forward, because there is damage occurring to our shorelines. There's damage occurring to all of our lakes, or at least most of them, with all of the increased traffic and that. And this is why we need to be concerned moving forward. I will volunteer my services again to help work on version 5.2 to get to version 5.3, if that's something that the zoning committee wants to do moving forward. But I do think that it is a big improvement over what we did have. Thank you.
Less than that. Benjamin Kurtzwell, 16040W West Lane, Hayward, Wisconsin. I would just agree with the other people who spoke about, I think we're getting close here. And like we said, we've taken over a year to do this. This is a long process. I don't see the problem of taking a couple more months to work out the tweaks before you send it to the towns. Because again, if these tweaks aren't made before they go to the towns, that could end in a negative vote from the town. So I think since we've taken so long and we're so close, let's take a couple more months and let's get some more input from other people in the townships and get it right the first time instead of trying to tweak it after it gets sent to the towns. Thank you.
Is there anyone online wishing to speak as part of these ordinance amendment proposal? I see some new people that just had jumped online. If you do wish to speak, either go ahead if you're already unmuted or raise your hand and I can unmute you. Well, hearing or seeing none there, so.
All right.
I do have Rebecca.
What's that?
Rebecca.
Go ahead.
Okay, thanks. Very briefly, as Jay mentioned, I did take a look at this. Andy Phillips also took a look at it. He was involved in the drafting of the original versions. And, you know, haven't given it the total legal thumbs up. And one of the issues, and I apologize because I haven't even had a chance to talk with Jay about this issue yet, is that because we are now addressing activity in the shoreland area, that essentially triggers the requirement of 59,692. And that's one of the differences between this version and the last version. And I applaud the cooperative efforts in putting this together. And, you know, I was there and I heard the town's concerns about that activity in protecting the shorelines and protecting the lakes. And that is totally a legitimate concern that the county can regulate in its ordinances. But we just have to make sure we follow the statutory process for doing so. And so I wanted to give that heads up that maybe, you know, that's going to be part of our tweaking process. So hopefully it will not change the end effect of what this does, i.e. protecting the shorelands. But it might look a little bit different in terms of the package it comes back in to make sure we comply with statutory requirements. Thank you.
Okay, thank you. Go ahead, Mr. Chairman.
Yeah, Mr. Chairman and Jay, I got a comment regarding when it does go to the towns, should we provide some, like yourself or Mr. Buckholz or any zoning committee member there to help answer any questions or be there in support versus, and I'm asking you, Mr. Chairman, because I know you are a town chair. Would that help at all, do you think? Not that we would take over the meeting, just that we were there to listen and maybe answer any questions, especially like Jay, to be there to assist with that.
Well, but I want to say, you know, this has been out there for a long time, been working on it. We're always going to have somebody that wants to tweak something no matter what you do with this. And my thought is, and this is my thought, that I'm okay with what I've been reading there, and I think we should send it to the towns. So that's just my opinion.
Yeah, and I was planning on attending the town board meetings that I can. Now, some town board meetings run at the same time, and I can't figure out how to be in two places at once yet. But yeah, would want to have some type of representation. You know, obviously, if there's, you know, committee backing, and that's ultimately what I want. I mean, this is not my ordinance amendment. Ultimately, I still think there are changes needed to the current ordinance to help me do the administration of the ordinance. But obviously, yes, I need the backing and support from this committee. And yes, I would like the committee to, you know, attend those town board meetings that I couldn't, to be, you know, a representative to help me administer the ordinance. So now if Rebecca still has some concerns and hasn't done her legal analysis, maybe it is a good idea to potentially have her do a full review prior to it going to the towns. That would be my ultimate, you know, worst case scenario is we send this out to the towns, and then in the interim, Rebecca, you know, throws up the red flag that, oh, you can't do this because I found something in statutes, and then everything just, you know, spirals out of control and we're back to square one. So that would be my only concern. You know, if Mr. Stover, Mr. Neese, and Ms. Roker want to help continue at a 5.3 version, as well as some of the other, comments that I had heard today, or if any other individuals want to give comments prior to the creation of a 5.3. But I would want to basically be ready to go for January zoning committee for discussion action to send to the towns in February to get this back to hold a public hearing, be it even still in potentially February, because we would still have time to get town responses in February and hold a public hearing at zoning committee in February to then go to county board in March, depending on what transpires during those events. Because like I said, I don't want a whole new batch of people to come into this and not understand anything we've been working on over the last year and a half come April elections.
Yes. Go ahead, Mr. Schuman.
Mr. Chairman, do you need a motion to that effect then, or are you gonna be good with just putting it on?
Well,
The
actually,
January
what we're
agenda.
Doing is postponing it. So does that give you time to tweak this to bring it back to the committee like Mr. Kurtzwell is?
I would hope so. And really, I guess it would be up to, to Rebecca, if we can get together prior to, the January zoning committee public hearing, and probably want to get something buttoned up by the end of the year here within the next couple of weeks. Obviously holidays mixed in there, but, whether it's later this month or early part of January to get everything squared away. So we have a 5.3 polished version ready to go.
Okay, yeah, so I would suggest that we postpone this until the January meeting, so you can, the two gentlemen, Rebecca and Jay, can go through this and do any tweaks that need to be done, so we can get this sent out to the towns and hopefully get it passed. I mean, we need to get something on the books.
And if there are additional comments about the proposed ordinance, those can be emailed to me. Whether or not we'll take those into consideration, that I don't know. But if you do have those comments, please provide them.
All right, are you making that motion, Mr. Schuman?
I am. Motion to postpone then until the January zoning committee meeting.
Okay.
I'll second that.
Okay, we have a motion by Mr. Schuman, second by Ms. Wilson to postpone the multi-dwelling development amendment until the January meeting. All in favor, say aye.
Aye.
All opposed? Motion carries. Go ahead, Mr. Neese. Quickly.
Anybody that has comments and some, sure, or has some, get an email to Jay, and so that they're on the table at the time when we're talking, so we're not spinning wheels. That's all.
All right, thank you. Thank you. All right. If no more business before the committee, we are adjourned. Thank you, everybody.
Thanks, Rebecca. We'll be in touch.
Thanks, Rebecca.
Thanks, everyone. Happy holidays.
You too.